Welcome to our fourth lecture in our series of videos to get you ready for the MPRE. In Lecture 1, we talked about the basics of lawyer regulation. Lecture 2, we talked about the fundamentals of the lawyer-client relationship. Lecture 3, we dealt with the business of law practice. And now in this fourth lecture, we're going to talk about the different roles that lawyers play and the different obligations that attach to a lawyer when she is playing the role of a counselor, the role of an advocate, the role of a person out in the community dealing with third persons. And finally, when a lawyer is dealing with people as a public servant. We'll take each one of them in turn and then conclude. Again, this is a relatively brief lecture, and then conclude our discussion of lawyers before turning to our discussion of judicial ethics. All right, now our discussion of lawyer roles. We'll start out by talking about the lawyer as counselor, then talk about the lawyer as an advocate. First, as an advocate before tribunals, obligation to avoid frivolous claims and to expedite litigation, to not lie to courts, to keep the decorum of the tribunal. Then move on to talk about the advocate, generally the obligations to opponents, the publicity issues, and prosecutors who are advocates of a special nature, namely ones with flags sewn onto their suits because they represent the sovereign. Then we'll talk about dealing with third persons, and then finally wrap up this portion by talking about lawyers as public servants. Okay, with that introduction, let's now turn to lawyers as counselors. Counselors. When a lawyer is acting as a counselor, she's not acting as an advocate. She's not trying to argue or appoint or persuade a decision maker. Rather, she's trying to lay out options for a client, evaluate something for a client that might be relied upon by a third person, and there's special obligations. All right, first of all, starting with lawyer as advisor. And here the lawyer must exercise independent professional judgment. That is, the lawyer's got to look out for what is best for the client and not for the lawyer or for some third person. The lawyer has got to render candid advice. That is, you just can't tell the client what the client wants to hear. You have to be candid. And you could, even if you're not asked as a lawyer, you can talk about other consequences of decisions, moral, ethical. That's allowed by Rule 2.1. These kind of economic, social, political issues are all fair game for the lawyer to make reference to in advising a client. Also, a lawyer can suggest consultation with another professional, like a psychologist or an accountant, and all that is fair game for a lawyer in advising a client. Next is the lawyer as evaluator. Now, this is when, for example, a lawyer might do a title opinion for a client who's getting ready to buy a house, might render an opinion as to whether or not the seller has good title to transfer to the buyer. When a lawyer evaluates the affairs of a client and reports to a third party, and as we've already talked about, title opinions, legal opinions, tax opinions about an investment, that's what we're talking about. And it's odd because, usually you are out representing your client, putting the best spin on things for your client. But suppose you're evaluating your client's title to property that the client is selling to someone. If you know that some third party is going to rely upon that, then there are special obligations. So in any event, it's okay for the lawyer to serve this role if the lawyer reasonably believes that the evaluation is compatible with the lawyer's other responsibilities to the client. What about harmful evaluations? You've got to get the client's informed written consent before releasing a harmful evaluation, like, for example, in my hypothetical, an evaluation in which the lawyer reaches the conclusion that the client does not have good title to the property in question. As to confidentiality, the ordinary rules apply, and you usually disclose this evaluation because you have implied authority to do so. Significantly, a lawyer can be liable to a third party for a subpar evaluation. Suppose the lawyer does a bad job in examining the title and some third party relies upon it. That third party may have a cause of action against the lawyer. All right, now let's talk about lawyer as negotiator. Now, this really doesn't fit into the lawyer as counselor very crisply, because as a negotiator, the lawyer's out at a mediation or a settlement conference, and he's advocating. So the lawyer is not really acting as a counselor, so it doesn't fit quite neatly here, but we have to address it somewhere, so here we go. All right, so as a negotiator, the overarching principle is that the lawyer can't make a false statement of material fact. Material fact. So, for example, if I'm at a settlement conference, I can't look at my opponent and say, yes, my client is alive, when my client is in fact dead. That is a material fact. Now, having said that, lawyers are free to lie about non-factual matters, like, for example, their opinions as to the strength of the case or the value of the damages. Those aren't facts, those are opinions. Also, immaterial facts, small things that don't really matter, lawyers can lie about those sorts of things. So, for example, the lawyer could go to the mediation, and say that he believes his case is worth $10 million, when in fact he really believes it's only worth about $100,000. That's a false statement, but not a fact. Lawyers, the simple fact of the matter is lawyers can lie about non-factual matters and immaterial things. What are factual things that are off limits for lies? Coverage issues, the existence of a document, the status of the client, you could go on, but those sorts of things are not fair game for lies. But allowed is puffing, statements of intention or opinions as to what might settle the case, valuations of price. Those are all things that are not material facts, and lying is allowed. All right, last issue is when the lawyer serves as a third-party neutral, usually as an arbitrator is what you're generally talking about, but also mediator, conciliator. It's okay for lawyers to do this, and special rules may apply to the lawyer, but those aren't going to be tested on the MPRE, and those special rules would be found in the, for example, if you're a AAA, American Arbitration Association arbitrator, in the AAA rules. The lawyer's only obligations under the lawyer ethics rules really are these. First, the lawyer must explain his role to the participants, explain that he's not forming a lawyer-client relationship with anybody, and that there is no confidentiality in what the lawyer is told. Last principle is that the lawyer can't later represent any participant without the informed written consent of the other participants. So the lawyer can't change roles from third-party neutral to lawyer without written consent. And this conflict is imputed to other members of the lawyer's law firm, but screening can solve that problem. Lawyers as advocates before tribunals have various responsibilities, the first of which relates to frivolous claims. A lawyer simply cannot assert a frivolous position, and by frivolous that means the lawyer can make no good faith argument under existing law for the cause of action or the defense, and can't even make a good faith argument to change the law. So this means that a lawyer has got to do some pre-suit investigation that's reasonable under the circumstances to make sure that a position the lawyer asserts is not frivolous. Now, in the criminal context, criminal defense lawyers are given a little bit more leeway in the sense that a criminal defendant can force the prosecutor to prove every element of a crime, even though the client may be very guilty and the evidence may be overwhelming. The defense lawyer can contest the charges and force the prosecution to put on proof beyond a reasonable doubt. All right, expediting litigation. This is somewhat of a corollary of the diligence principle. A lawyer has got to make reasonable efforts to expedite litigation, to move cases along. Now, if the client has an interest that's contrary to that duty to expedite, for example, if the client wants to drag things out, for example, then the lawyer does not have to harm the client's, and here's the key, legitimate interests. And delay for financial benefit is not a legitimate interest of a client. So, for example, an insurance company, if it just wants to delay things out because it wants to collect interest on the money, that's not a, quote, legitimate interest of the client, and that would violate the lawyer's obligation to expedite litigation. Lies, candor to the tribunal. This is really one of the funnest topics to deal with in a legal ethics class, but it's fairly straightforward for purposes of the MPRE. As to statements made about the law, a lawyer can't knowingly, and again that's knowingly, that's subject of actual knowledge of falsity, a lawyer cannot knowingly make any false statements of law. Now, suppose a lawyer makes a material false statement of the law and then comes to learn about it later. He doesn't knowingly make it. He thinks it's right when he makes it, but he comes to learn that it was wrong. Well, again, if it was material, then the lawyer has an obligation to correct it. And keep in mind, look at the difference here, because the lawyer can't knowingly make any false statement. He only has an obligation to fix an unwittingly made material false statement. And finally, as to the law, the lawyer must reveal directly adverse authority in the controlling jurisdiction. The key words here are controlling jurisdiction and directly adverse authority. So it can't just be persuasive authority against the lawyer. It's got to be controlling, and it's got to be directly adverse to the lawyer's position. All right, so that's as to law. What about a lawyer's obligation to disclose facts? Well, no general obligation to find or report bad facts. Remember, we have an adversarial system, and it's up to our adversaries generally to go off and find the facts and to show the decision maker that his opponent is wrong. That being said, in an ex parte proceeding, a lawyer has an obligation to be more forthcoming, to disclose more to the decision maker. Why? Because it's ex parte. There's nobody there to tell the judge the other side of the story. So for that reason, there is an obligation to be more forthcoming. You, of course, have to turn over bad facts in response to lawful discovery. And if you're a prosecutor, you have a duty to turn over Brady information. That is, information that tends to exculpate the defendant or would tend to mitigate punishment. All right, what about a lawyer's assertion of facts that are wrong? And again, now this is where we're talking about lawyers speaking. In a second, we'll talk about witnesses, but now we're talking about lawyers. All right, a lawyer can't knowingly make any false statement of material fact. That's the same as this. You see, you can't make any false statement of material fact or law. And if the lawyer makes inadvertently a false material statement, then the lawyer's got to fix it. Again, this is the same as this up here. The same obligation exists as to facts and law. You can't knowingly make any false statement of fact or law. You've only got to fix material false statements, not immaterial ones. What about witnesses? Suppose your witness takes the stand, or tells you he wants to take the stand and lie. Well, a lawyer can't knowingly offer any evidence that the lawyer knows to be false. So if you know your client's lying, you can't call the witness. But suppose he takes the stand, he swears to you he's going to tell the truth, swears to the court he's going to tell the truth, and he gets up there and he lies. Well, if the lie is material, then the lawyer must take reasonable remedial measures, which includes, and again, this is the goofy word in the comments, remonstrating in private with your client. But ultimately, he might have to rat the client out by disclosing the lie to the tribunal. And the Rule 1.6 obligation of confidentiality is not a limitation on his obligation to do this. This duty runs until the very end of the proceeding. But if the lawyer, for example, learns a couple of years later about the lie, the proceeding is over by then, and the lawyer's got no obligation to fix the lie. Okay, so we've just talked about candor to the tribunal. Let's talk about decorum of the tribunal. Well, obviously, a lawyer's got an obligation to reveal corruption, bribery, those sorts of things. The lawyer must reveal corruption of proceedings by any person. Rule 1.6 is not a problem. That is, he can't fall back on his confidentiality obligation as an excuse for not doing that. This duty lasts till the end of the proceeding. A lawyer can't seek to influence a judge, improperly influence a judge, an official, or a juror by improper means. Ex parte communications. You can't call the judge and talk to him about the case. Now you can write him a letter and CC other counsel, that's fine. As to jurors, during trial, you can't talk to them at all. After trial, it's generally okay unless there's some legal prohibition, unless it would constitute harassment, or unless the juror stiff-arms you and you still harass him and you talk to him. That's not appropriate. Disruptive conduct, like for example, fighting. I've had that in my practice, lawyers fighting with one another. Lawyers cannot engage in conduct that's intended to disrupt a tribunal, and includes in court and conduct at depositions. Lawyers can't knowingly make false statements regarding the qualifications or integrity of a judge or a candidate. Sounds a little bit like a restriction on speech, and it is. A lawyer running for office must comply with the Code of Judicial Conduct. All right, what about legislative proceedings, administrative proceedings? A lawyer, if, for example, a lawyer appears before a legislative panel and advocates in favor of the adoption of some law. If he is appearing in a representative capacity rather than in his capacity as a private citizen, if it's a representative capacity before a legislative board or other rulemaking body, he's got simply to disclose. He doesn't have to disclose who his client is, but he's got to disclose that he's there in a representative capacity. Now, as to the duty of candor under these circumstances and those sorts of legislative or administrative proceedings, it applies. That is, the duty to rat out lies and everything, if it's an official hearing with evidence and argument such that it's like a trial. But it doesn't apply if the lawyer is representing a client in bilateral negotiations with the government, if the lawyer is representing the client in a license application proceeding, if it's a government investigation involving the client, or the government is examining the client's compliance with reporting requirements. The whole key here is it's got to look like a trial with evidence and arguments in order for this duty of candor, like this duty over here, to apply under those circumstances. Other duties that lawyers have as advocates. And let's start with fairness to the opponent, which sounds a little odd that you've got to owe your opponent this duty to be fair. After all, you're trying to beat him. But that's what this obligation is all about. You need to beat him, but you need to beat him within the rules. So what are the rules? Well, first of all, a lawyer cannot obstruct his opponent's access to evidence, including by altering or concealing a document. A lawyer can't falsify or assist a witness to testify falsely. You can't offer a witness a bribe. You can't say, hey, why don't you just change your version a little bit? That's inappropriate. As to payments to witnesses, you can't offer inducements that are prohibited by law. Now, having said that, some things are okay, like travel, meals, and lodging you can pay. You could pay reasonable compensation for the witness's loss of time away from the office, for example. You could pay an expert witness for time spent preparing and testifying. Now, the payment can't be contingent on his testimony or outcome, because that would be an improper payment to a witness. Can you encourage a witness not to cooperate? Answer, no, you can't advise a witness to be unavailable. However, you can advise a witness to refrain from giving information voluntarily, and essentially tell the witness to demand a subpoena, for example, or to wait until a deposition rather than just giving into a voluntary interview, if and only if the witness is a relative, employee, or agent of the client, or the witness is a client, and the lawyer reasonably believes that the witness's interests won't be harmed by refusing to cooperate. This is fairly obvious, but a lawyer cannot knowingly violate laws, rules, or orders of a court. A lawyer can openly violate a rule to challenge its validity. Discovery abuse. A lawyer can't make a frivolous discovery request, and a lawyer must make reasonable efforts to comply with lawful discovery. Trial tactics. A lawyer can't refer during argument or otherwise to irrelevant or inadmissible evidence. A lawyer can't assert personal knowledge of contested facts. For example, a lawyer can't say, "Ladies and gentlemen, my client is innocent." A lawyer can't state a personal opinion regarding the justice of a cause, credibility of a witness, guilt or culpability of a party. It's all about the evidence. It's not about the lawyer interjecting herself into the proceedings. Threats. A lawyer can threaten non-frivolous criminal charges to gain an advantage in a civil case only if it's closely related. So, for example, a lawyer can say, "I know you broke into my client's house and stole money. If you repay the money, we won't turn you into the police." That's not extortion. However, if he says, "If you don't give my client some money, we're going to turn you into the police for rape," that's extortion. Why? Because the threat is not closely related to a civil case. A lawyer can't threaten disciplinary report regarding an opposing lawyer in order to gain an advantage in a civil case. Can't use the disciplinary process to gain an advantage, or threats of that. Publicity. A lawyer cannot make an extrajudicial public statement that the lawyer, here's the key, reasonably should know has the substantial likelihood of materially prejudicing a case. Not many statements do that. Again, the First Amendment gives lawyers an ability to talk, but they can be gagged only as to extrajudicial public statements that a lawyer reasonably should know have a substantial likelihood of materially prejudicing a case. Not many statements fit that bill. A lawyer, however, can reply to recent publicity not initiated by the lawyer or the lawyer's client. What about the lawyer as a witness? Sometimes lawyers have to take the stand. A lawyer cannot be both trial counsel and a necessary witness. Now, he can be he can do pretrial work, even if he's going to be a trial witness. Pretrial work is okay. That's what that branch says. This conflict is not imputed to the lawyer's firm. So if one lawyer needs to be a witness, then he could get his partner to serve as the trial counsel. Now, all that being said, there are times when it is simply okay for a lawyer to be both an advocate at the trial and a witness. When? Well, one, if the testimony is uncontested or just a mere formality, or the testimony relates to the nature and value of the lawyer's services, like the lawyer needs to take the stand to talk about how much work he did and how much his invoices were. And finally, a catch-all, the lawyer can testify if his disqualification would cause, and here's the buzz term, substantial hardship to the client. Prosecutors. Prosecutors are special types of advocates. They are not just lawyers, they are representatives of the state. And as a result, they have special obligations. And in fact, it's odd if you think about it. They're the only type of lawyer who has a rule of conduct dedicated only to them. So what are the rules that govern only prosecutors? Well, first of all, as a general matter, prosecutors must seek justice, not just to convict. A prosecutor can't prosecute unless he's got probable cause to believe that the defendant has committed the charged crime, and by probable cause, what that means is enough evidence to suggest to a reasonably prudent person that a crime was committed and that this defendant committed it. A prosecutor must protect the accused's right to counsel. A prosecutor can't seek waiver of important pretrial rights from an unrepresented defendant. Here's the Brady obligation. A prosecutor must disclose known exculpatory information to the defendant, and that includes information related to guilt, and including witness impeachment, and that might mitigate punishment. In order to prevent harassment of criminal defense lawyers, the prosecutor cannot issue a subpoena to a lawyer unless the evidence is not privileged, is essential, and is otherwise unavailable. Now, remember we talked about publicity by lawyers in general down here, right? Now we're going to talk about public statements by prosecutors, and there's a big difference between these. When we talk about lawyers in general down here, they have really only just a few types of statements that they can't make. When we talk about prosecutors, they need to keep their mouths shut more than regular lawyers. What is the rule? Well, here we are. A prosecutor cannot make an extrajudicial statement if there's a substantial likelihood of heightening public condemnation of the accused. Again, it doesn't have to cause material prejudice. It's prohibited even if it would just heighten public condemnation of the accused. That being said, it's okay for prosecutors to talk about dry facts relating to the charge, recite publicly available info, talk about scheduling matters, request information and issue warnings to the public, can give routine booking information. Wrongful convictions. This is a relatively new development, and this gives prosecutors the obligation to help get innocent people out of jail. First, if the prosecutor has new credible evidence that there's a reasonable likelihood of a wrongful conviction, the prosecutor must disclose the evidence. If the prosecutor has clear and convincing evidence of an innocent defendant in the prosecutor's jurisdiction, he's got to go further, not just disclose the evidence, he's got to seek to remedy the conviction. So again, very broad duties there imposed upon prosecutors to pursue justice and to right wrongs committed to innocent defendants. Dealing with third persons. Of course, lawyers, when they're out lawyering, they get out and they talk to witnesses, talk to opponents, talk to members of administrative agencies. Do they have to be truthful? Well, generally, a lawyer has no obligation, none, to inform a third person of relevant facts. However, a lawyer cannot affirmatively misrepresent facts. The lawyer can't knowingly make a false statement of material fact or law to a third person. Now, there are times when a lawyer's mere failure to disclose a fact is a problem. When is that? A lawyer must disclose material facts when necessary to avoid assisting a client in a crime or a fraud, and unless Rule 1.6 prohibits the lawyer from disclosing. What about dealing with represented persons, people who have their own lawyers? The thinking here is we want the lawyer to contact the represented person's lawyer. We don't want them going directly to this represented person without their lawyer present. And this is the general rule right here. The lawyer can't communicate with a third person if the lawyer is acting for a client and the lawyer knows that the third person is represented by counsel with regard to the matter that he wants to discuss. So as to that first point, if the lawyer talks to a client not in a representative capacity, but because, for example, the client may want to hire him as substitute counsel, the person has a lawyer now but wants to think about hiring this lawyer as their new lawyer. Well, that's not a lawyer acting for a client in that communication, and that would be okay. The lawyer also needs to know, not should know, but know that the third person is represented by counsel in the matter, not just generally represented by counsel, but represented by counsel in the matter that the lawyer discusses. About represented organizations, when can a lawyer talk to an employee of a company? Like, for example, suppose the lawyer is a plaintiff's personal injury lawyer and he represents a plaintiff in a case against the railroad. Can the lawyer go out to the railroad yard and talk to employees of Kansas City Southern Railroad? That's our hypothetical. Well, the short answer is yes. Remember, the lawyers have to do due diligence and have to investigate their cases, so we expect them to go out and interview witnesses. So it's generally okay for the lawyer to do that. However, a lawyer cannot communicate with a present constituent. Former employees are always fair game, but can't communicate with a present constituent who fits into one of these three categories. Can't communicate with a present constituent who supervises, directs, or regularly consults with the organization's lawyer about the matter. Cannot talk to a person whose conduct may be imputed to the organization. And cannot talk to a person who has authority to bind the organization about the matter. For example, somebody who can settle the case. Those people are off limits. Everybody else is fair game. It's also okay to communicate with a represented person if the lawyer has the consent of the third person's lawyer, if the lawyer is authorized by law or court order to communicate, like sometimes the First Amendment allows you to communicate with a represented governmental entity. The lawyer can communicate with somebody if it's not in a representative capacity. Remember, we already discussed that up here. That's what that's all about. Lawyer can communicate if the communication is not about a matter on which the third party is represented. We talked about that up there, right here. And it's always okay for clients to talk to one another directly without lawyers. Sometimes that's what it takes to get the case settled. Okay, unrepresented persons. These are people who don't have a lawyer. Lawyers can talk to them, of course, but they must not state or imply that they are disinterested. If the lawyer knows or reasonably should know that the unrepresented person is confused about the lawyer's role, then the lawyer's got to take reasonable efforts to correct the misunderstanding. If the lawyer knows that the third party has conflicting interests, then the lawyer shall give no legal advice other than the advice to the person to go out and get their own lawyer. And other than that, the lawyer is otherwise free to negotiate or settle with an unrepresented person. Finally, respecting the rights of third persons with whom the lawyer deals. The lawyer must not use means that violate the legal rights of a third person or that have no substantial purpose other than to embarrass, delay, or burden a third person. And finally, as to missent faxes, inadvertently sent emails, etc., if the lawyer knows or should know that the communication was sent in error, the lawyer simply has an obligation to notify the sender. The rules of professional conduct don't go any further than that as to what is now going to happen with the improperly sent email. All the lawyer's got to do is put the sender on notice, and then it really puts the monkey on the sender's back to figure out what to do about it. Lawyers as public servants. What obligations do lawyers have in this regard? Well, first of all, a lawyer has a pro bono obligation. Now, obligation is a big word here because Rule 6.1 imposes a very diluted obligation. It says that a lawyer has a professional responsibility to provide legal services pro bono, and that a lawyer should aspire to do 50 hours per year of pro pro bono, the majority of which should be for the poor. Now, the rule then goes on to say there's no disciplinary enforcement of this, quote, professional responsibility. And note really how diluted this is. It's all you have to do is aspire to do 50 hours and you've satisfied this so-called professional responsibility. So let's all take a moment of silence to aspire to do our 50 hours of pro bono. Did that feel good? Because you've satisfied your obligation. All right, legal services organizations. A lawyer can serve an organization that is adverse to the lawyer's regular clients. So, for example, you can be on a board, for example, of the ACLU, even though you represent businesses that might get sued by the ACLU. A lawyer is an officer of a legal services organization, does not have a lawyer-client relationship with all of the clients served by the organization. A lawyer can't knowingly participate in decisions of a legal services organization if incompatible with the general conflict rules, or if it would adversely affect the organization's clients who are adverse to the lawyer's private clients. Quick advice programs. These are hotlines. Lawyers must obtain the client's informed consent to a very limited scope representation, which is basically we're just going to talk on the telephone for a few minutes about your issue. The conflicts rules are relaxed, and it's only misconduct if the lawyer knows of a conflict with the person on the other end of the phone. And the conflict created by quick advice is not imputed to the lawyer's firm. The ordinary rules apply if that quick advice client later becomes a real client and actually hires the lawyer. Law reform activities, like for example, if a lawyer were to participate in the American Law Institute. A lawyer can serve as a member of a law firm group even though the reform may hurt the lawyer's clients. Suppose you represent banks and the Law Institute is working on new banking laws that are not very bank friendly. The lawyer can still serve as a member of that reform group. If the lawyer knows that a reform may materially benefit the lawyer's client, the lawyer must disclose that fact, although he need not identify the client. And finally, political contributions. This is the anti-pay-to-play provision. That's what it's commonly known as. And look how toothless this is. A lawyer may not accept government legal work or a judicial appointment if the lawyer made or solicited a political contribution for the purpose of obtaining employment. So you can give money to a judge or to a governmental official running for election and then take an appointment from them later, as long as when you gave them the contribution, it wasn't for the purpose of obtaining employment. The lawyer is always going to say it was for the purpose of electing a worthy candidate. So for that reason, this is not really much of a anti-pay-to-play provision in practice. This doesn't apply to services that a lawyer does on an uncompensated basis, or as to appointments based on independent selection process, or as to appointments based on a random or rotating process. So there it is. That is our discussion of the different roles that lawyers play: counselor, advocate, public servant. And now that we've finished our discussion of legal ethics, which is the lion's share of everything you need to know for the MPRE, let's turn in our next and last lecture video to the obligations of judges.